Let's get back to it.
Fulton County judge is expected to rule on a mistrial motion in the YSL RICO case that we've been following here on Atlanta News First for nearly a year since witness testimony began. It comes after information was brought in front of a jury that they apparently were not supposed to hear. The jury was excused while Fulton County Judge Paige Whitaker weighed the request for mistrial, ultimately canceling court for the day yesterday and again today. We have a lot to get into, but for more on how we got here and where we are right now, explain to me exactly what happened yesterday.
This is the best popcorn trial that has ever happened. The longest criminal trial in Georgia history. We have all the big players and a celebrities involved. One of our homegrown most famous entertainers is battling literally for his life in the longest and most complex prosecution in Georgia history. So what happened yesterday? Well, to just catch people up, y'all know we're on this second judge, and there's been a lot of fighting over what evidence was going to come in and what evidence was going to be restricted or excluded. That started with Judge Glanville. It's continued with Judge Paige Reese Whitaker, who is currently the elected Superior Court judge trying this case, or at least trying to try this case. One of her outtakes yesterday involved her commenting on how she's trying to save this case from being wasted 12 or 18 months because of sloppiness, and that's because of the testimony that we are hearing. Previously, we have had multiple instances where witnesses, almost exclusively state witnesses, have testified to information that they should have been told by the DA's office they were not supposed to get into. That's part of basic witness preparation. There are going to be issues that are excluded by the judge or prevented by the rules of criminal litigation from being introduced in front of a jury, with the remedy being, if those rules are broken, that something has to happen with the case, including dismissals. If the cat gets out of the bag, if the bell gets rung, you can't put those facts back together in a way that preserves the defendant's constitutional rights. And that's really where the analysis is. Are the constitutional rights of the defendants being met when there's this unsolicited testimony? So what happened yesterday? An officer, kind of in summary, basically referenced somebody's prison sentence in a way that wasn't admissible. And a juror knowing, or all of the jurors knowing, about someone being previously convicted or incarcerated, that's bad character evidence. And it's not appropriate for the jury to hear because it would impugn their ability to make an independent judgment. Now, most of the time, these kind of simple mistakes are fixed with a curative instruction. Oftentimes, the jury doesn't even understand what happened because the discussion about all this happens outside their presence. When there is an issue like we saw yesterday of a witness testifying to something that shouldn't be out in the wild, the judge kicks everybody out of the court and talks with the lawyers, and they figure out what they're going to do next. Yesterday, we saw an extensive interchange between Judge Paige Reese Whitaker, the state, and the defense over this unexpected, unsolicited slip-up by a state witness, but it still had the effect of wrongfully providing information of bad character in an incorrect and unconstitutional and wrongful manner to the jury. The defense immediately moved for mistrials, and during that discussion, it became very clear Judge Paige Reese Whitaker would not grant at that moment a mistrial with prejudice. And with prejudice means that the state can't come back and retry the case. It's dismissed. The state doesn't get another bite at the apple. Or what she really looked to be leaning in on was the possibility of a mistrial without prejudice. That could and would preserve District Attorney Fani Willis's ability to bring back charges against Young Thug and the other co-defendants. There's about 6 or 7 in this trial, and then, of course, there are a few that have been removed. They've been severed from this trial, and, of course, others have already pled guilty. In fact, we're seeing we've got another probation revocation coming up due to one of the state's witnesses in this trial getting arrested and violating probation. So what happened after Judge Whitaker stopped yesterday? Because when she stopped, she basically said, hey, y'all, I got to think about this. She asked the defense what their opinion would be on a dismissal or mistrial, rather, without prejudice, thereby preserving the state's ability to come back. And the defense had a lot of thoughts about that. There are wins with a mistrial of that nature, but then there are big losses as well, continuing exposure for all of the co-defendants, and each co-defendant may face a different form or flavor of criminal exposure with a mistrial. For example, one of the big questions is this speedy trial. There is a speedy trial demand that's been filed, and there are legitimate academic questions of whether there would be a possible second trial or whether a second trial would automatically violate the listed speedy trial. Tough stuff. Paige Reese Whitaker then met, or sorry, not Paige Reese Whitaker, DA Fonnie Willis then met with the defense teams over the last day.